Good morning, everyone. My name is Scott Fields. I'm an attorney working with Magellan Legal. Thought I was going to get an introduction, but apparently I'm not. So I'll just go ahead and get started if that's okay with y'all. Today, I'm going to be talking just a general overview about the probate process, which is the process of dealing with someone's estate after they've passed away. If you want more information about this after the presentation, you're welcome to get in touch with me. My contact information will be at the end of the presentation. But for now, let me go ahead and share my screen and we will get started. Let's see. That's it. Let's go. So, as I mentioned before, this is the probate process. My name is Scott Fields. I'm working with Magellan Legal. I am an attorney. Because I'm an attorney, let's go ahead and do the disclaimer. So, this presentation is not legal advice. And I, as of right now, am not your attorney. Just watching this presentation does not make me your attorney, and it does not make you my client, unless you want to hire me, in which case, great. Otherwise, I'm not your attorney. And this information only applies to Georgia. Every state has different laws regarding probate. Sometimes those laws are a little bit different. Sometimes they are very different. So please do not take any of this information and attempt to use it in another state other than Georgia. It's a brief disclosure about Kevin Metters, who's the attorney here. Okay, all right, so now I'll go. So just like anything, we're going to start with some definitions. The decedent is the name of the person who has died. That's what they're called in all the official documentation. If you pull some files, forms from the probate court, that's the term that you will see to refer to the person who has passed away. An asset is something that the decedent owned. It's what they had during their life. It's real estate, it's financial accounts, it's money in the bank. It can also be a legal claim. Sometimes I'm asked to come in and help with a medical malpractice claim if someone has already passed away. That legal claim can survive someone's death. And so that is technically an asset, even if it has not yet been reduced to a judgment, even if there's no money yet. Just the fact that something has happened is technically an asset. Liability is what the decedent owed to someone else at the time of their death, whether it's a credit card bill or a mortgage, or again, a legal claim against them. Somebody is suing them or potentially could sue them. That's a liability. And an estate is simply the decedent's assets and liabilities when they died. It's really nothing more than that. It's a combination of those two things. So estate administration is the general term for the process that we go through. It is collecting and preserving the estate's assets, and it is settling the estate's liabilities, whether those liabilities are simply paying off claims or dispersing assets to heirs or beneficiaries, which we'll talk about in a second. Probate, the term probate is used for quite a few things, actually. It comes from the Latin to prove. It is also the name of the court. The probate court is where estates happen in Georgia. Again, other states have different names for the court, but here it's the probate court. And in Georgia, the probate court does other things in addition to estates. Sometimes they'll handle gun licenses, in some cases marriage licenses, that sort of thing. And then finally, probate can refer to the process itself of estate administration. Technically, probate only applies to wills. We only probate wills in Georgia. And if there's not a will, the term probate does not apply. However, people use that term all the time, and I'm not going to get mad at you if you do. It's not that big of a deal. Heirs. Heirs are the people who are going to receive assets if there is no will. Everybody has legal heirs. Even if there's not a will, and even if someone is not in the will, right? If you have a will and someone has been left out, but that person meets the legal definition of an heir, they're still a legal heir. The law decides who an heir is, not the decedent. The beneficiaries, sometimes called the devisees, are the people who receive assets under a will. If there's a will, the people who are going to get something under the will are the beneficiaries, and that is something that is decided by the decedent, even if those people are not the heirs. That happens all the time. And finally, even more definitions. A personal representative is the person who's appointed by the probate court to administer the estate. And that's just a general generic term. If there is no will, that personal representative is called an administrator. If there is a will, that personal representative is called an executor. So personal representative is a generic term like car, whereas administrator and executor are more specific, like station wagon or truck or coupe or things like that. In just general talking, they can be interchanged. They can be used. You can use any of those terms. It's fine. If we go to court, then we need to use the right term. But other than that, it's not that big of a deal. So here is an overview of the probate process. Different folks will have different number of steps depending on how they collect things. This is kind of my breakdown. And we will go through all of these in a little more detail in just a few minutes. But step one is collecting information. Step two, after we have the information, we file the petition. And then hopefully we get letters from the court. Once the letters are given, we set up the estate and then receive claims. And after the claims have been received, we pay off the debts of the estate. And then once all the debts have been paid, then we disperse assets to the heirs or the beneficiaries. So that's just a very, very high level overview. So throughout the entire process, the administrator or the executor will be collecting assets, which means finding what's out there, finding the accounts. When the time comes, getting money out of the accounts or potentially finding out what property is there and securing the property, making sure that nothing happens to it. And collecting assets is something that goes from day one, pretty much all the way through almost the end of the process. And then preserving assets, making sure that nothing loses value. And preserving assets means things like notifying the banks so that automatic drafts can't come out or somebody else can't use a debit card, which is something we've dealt with before. Notifying creditors so that they can stop applying interest onto an account if that's applicable. And then preserving assets includes things like paying certain bills, but only the ones that are necessary. Like, for example, if there's a property, a house or a real estate that has a mortgage or a loan on it, that mortgage may need to be paid in order to keep the property from being lost to foreclosure. So, some bills need to be paid. Some bills don't. You generally should ask a probate attorney about, if you're in that situation, do you need to pay this bill? Do you need to set that bill aside to pay later when the claims are paid? So step one, collecting information. This needs to be done before we file anything with the court. In days past, what we would do is I would tell my clients, just collect someone's mail. After someone passes away, collect their mail for 30 days or a month. And by doing that, you're going to get a pretty good information of what assets they have available and what liabilities, what debts there are, right? Bank statements, financial statements, credit card bills, mortgage statements, those sort of things. Those things that come in the mail, usually about once a month, sometimes quarterly, but again, that's something that can be discovered simply by checking the mail. These days, we also tell folks to check email since so many of these statements are no longer coming by paper. Also, before filing the petition, you need to see if there's a will. If there's a will, you need to try to find it. And this includes going through someone's filing cabinets, safe deposit box, all these sorts of things. Because if there's a will, it's a different process in terms of how easy certain things are going to be. Or if you determine that there is no will. And if you do have a will, it would be very, very helpful to have the original. Most of the time, the courts want the original. If there is only a copy of the will, it is possible to try to probate the will, but it can be difficult. And then the last thing to do is you do need to identify the heirs. As we mentioned before, the heirs are the people who are legally determined. And generally the definition is that it's the people who would receive something if there wasn't a will. Georgia law requires that those people, the legal heirs, be notified that a petition has been filed and have an opportunity to say something, to respond, to object. And so you need to find all the legal heirs before you can file the petition. You also need to determine what the assets are. Some of the petitions that need to be filed, you need to list, or at least do your best as you can, list the assets of the estate. Not all the petitions require that, but some of them do. And then finally, what are the liabilities? This isn't something that goes on most petitions, but it's still something that is good to know. So you don't necessarily need to know all the liabilities before you can file, but you do need most of this information before you can get things started with the court. All right, once you've got all the information, you fill out the petition, which is the document that goes to the court to start the estate process. And where you're going to file that is that's filed in the county of the last residence of the decedent. So I had this question yesterday, actually. If someone lives in DeKalb County, for example, but has a car wreck and then goes to Grady, which is in Fulton County, before they pass away, well, do you probate in Fulton County, which is where the person died, or do you probate in DeKalb County, which is where they resided when they died? And the answer is DeKalb County in that case. It's this county of last residence. If someone is in a nursing home, it can get a little more complicated because it depends on how long they were there and whether it was their choice and a number of different factors. So if someone has been in a nursing home, determining what county to file can be a little more difficult. And again, ask a probate attorney. The two most common petitions that we see are to probate a will in solemn form, which is what you do generally if there is a will, and petition for letters of administration if there is not a will. These are by far the most common two petitions that we file, but there are 10 to 15 different petitions, depending on the circumstances, that may be something that you need to file instead of the solemn form probate or the administration petition. Probably the third most common that we see are years support. Years support is something that Georgia has that protects a surviving spouse or a surviving minor child and allows them to receive certain assets in advance of any creditors. That is a complex topic, and I'm not going to be discussing that today because it doesn't follow the same path as probating an estate itself. Another one that we sometimes see is temporary administration. You do this in an emergency to try to get some authority. Someone who's appointed as a temporary administrator has the authority, some authority, to collect assets, but not really any authority to pay out any assets. So if there's a house that needs to be protected or sealed against intruders, if there are crops that need to be sold and you need somebody with legal authority, that is something that you would get a temporary administrator appointed for. Like I said, there are a bunch of others, and it may be a good idea to talk to a probate attorney before you get started to find out which of these petitions you need to file, because it's very, very circumstance specific. After the petition is filed, usually a couple of months, the court will issue letters. Letters is just basically an old term for an order. It's an order from the court granting someone the authority to carry out the acts that are needed to deal with the estate. Until the letters are issued, nobody has legal authority to act on behalf of the estate. So if there's a will, those letters are called letters testamentary or letters testamentary, depending on where you're from. And the personal representative in that case is called the executor. If there is no will, then the letters are called letters of administration, and the personal representative is called the administrator. If you are talking to someone in another state, or if you're talking to like a national bank, they may get these crossed or confused. I've had plenty of people ask us for letters testamentary when there's no will, and again, we just kind of send them what we've got, and they're usually okay with it. After the letters are issued, it's time to set up the estate. This usually takes about 20 minutes. It's really not that big of a deal, but it is important if cash is going to be coming into the estate, whether it is from liquidating an asset, like selling a house or closing an investment account, or whether it is from closing a checking or a savings account, so that that money can then be moved to the estate. You'll need to get an estate bank account, and in order to get an estate bank account, you'll need to get an employer identification number, or an EIN. This is the same number, and it's the same process for getting an EIN for a new business, like for a corporation or an LLC. It's the same thing. You just check different boxes. It's basically the social security number for the estate as an entity itself. The next step in the process is to receive claims. One of the first things we do as soon as letters are received is we go ahead and publish what's called a notice to debtors and creditors. And this is a little ad that follows a pattern. It's a format that gets published in the legal newspaper of the county and has to run for 4 weeks. It's published for 4 weeks in a row. And then after that publication runs, after the last date of publication, there's a waiting period. We wait 3 months. And in that 3 months, what we're waiting for is we're waiting to see if any claims come in. Creditors have to submit something in writing to us so that we know that there's a claim. If they do that, then we know that there's a claim that needs to be paid or negotiated away. And there's not really anything that can be done to shorten this period. So basically, after the letters are issued, there's kind of 4 months of doing some minor work and then sitting and waiting for things to come in the mail. And we're, like I said, during that 4 months, we're basically receiving written claims. If people ever call me, I'll get creditors to call on the phone and we tell them, please send me something in writing just so we've got something official. Some creditors like to file with the court. That's not really necessary in Georgia, but it doesn't hurt. Once that 4 months ends, it's time to pay the debts. And this all happens before any assets are distributed to beneficiaries or to heirs. So the debts come first, which is a surprise to some people, but this is what the law requires. And there is a priority of who gets paid and in what order. And the priority usually applies, or the purpose of the priority is if there are not enough assets to pay all the debts, right? Somebody's got to get paid first, and that's prescribed by law. So first priority is year support. If we go through the year support process, and if the court grants an order of year support, then that is the first priority, and it comes in front of literally everything else. So it's a great way for a surviving spouse to kind of deal with the estate. But if there's no year support, then the next one is funeral expenses. Funeral expenses reimbursement or payment of funeral expenses comes next. It's at the top of the list for most estates. After funeral expenses, there are administrative expenses. So these are the things that are paid by the administrator or the executor in the process of administering the estate. So it's things like attorney fees, CPA fees, any storage expenses, if you have to move a bunch of stuff to storage so that you can sell a house, if you have to rent a safe deposit box so you can store valuable items, and travel expenses in some cases, if the travel is just related to, is simply related to administering the estate. It is not things like chartering cars or a bus to go to the funeral, which is one that somebody's asked me about. After administrative expenses come the expenses of the last illness. This is not old medical bills. This applies to medical bills related to the final illness of the decedent. Those need to be paid. After that comes taxes, federal and state taxes. And then after that are what are called secured debts. So these are liens or any kind of loan that has collateral, like a car loan or a home loan or things like that. Those get paid. If they weren't paid off when you sold the asset, then they get paid off at this level. And then finally are unsecured debts. And this is credit cards. It's credit cards, it's old medical bills, it's a loan that was written on the back of a napkin that didn't have any collateral attached to it. So once all of those things are paid, and in that order, if there is money left over, then that gets dispersed to the beneficiaries according to the will, or if there is no will, then according to the heirs. And that goes according to the laws of intestacy. Georgia has very specific laws about who gets what and who gets how much if there's not a will. I've had some people come to me who thought that if there's no will, the administrator of the estate gets to decide. And that is not true. I've had people come to me and ask, does everything just simply go to the spouse, even if there are children or grandchildren? And the answer is no. If there are children or grandchildren, they are also included. People will sometimes ask whether an estranged child or an estranged spouse, even if they're still married, receives anything. And the answer is yes. If there is no will, spouse and children or descendants of children receive something according to Georgia law. So if you want to decide who gets what, a will is the way that you would avoid intestacy, that kind of state mandated distribution of assets. It is only family members, by the way. Legal heirs are only family members. It is not spouses of children. It is not stepchildren unless they've been adopted. So it's very strict. Finally, complications, things that can make this process take longer or make them more complex or just simply gum up the works. If there are unknown heirs, which means we know that somebody exists, but we don't know who they are. So there's, I've got several situations where the family is pretty sure that there is a child out there that was born out of wedlock and nobody really knows exactly where they are or what their name is. That's an unknown heir. And that person, we need to try to find that person. Or if you know that there is a person, you know that there's a child, you may even know their name, but you don't know their contact information and you just can't find it. Well, in that case, the court is going to appoint what's called a guardian ad litem to try to find that person and to review the petition on their behalf. And that is going to add several months, especially now that there's COVID. Pre-COVID, it was a 2-month minimum. Now it's 3-4 months easy. If there are uncooperative heirs, again, all heirs get served with a copy of the petition, and they can cooperate and make things go much more quickly. They can cut weeks or months off the process if everybody cooperates. If you have even one heir who doesn't cooperate and doesn't sign forms, well, now you're back to having to get them served officially and formally. So you're talking about another couple of months. Another thing they can do to be uncooperative is to file an objection. Called a caveat. If they file an objection, it's pretty much an automatic 6-month delay while the court looks into the objection and while the court gives people time to get ready for the hearing. Most of the time, in my experience, during that 6 months, the parties can come to some agreement, but if they don't, it's going to take a while. And so that's why the objection or the caveat is listed as a complication. It's pretty much the biggest complication we deal with. I skipped one. Finding the original will can be a complication. Again, if you've got a copy or a scan, but you can't find the original, well, you kind of need to spend some effort to try to find the original. But if you can't, like I said, there are things we can do, but it is going to add some time. It's going to add some expense. So if you have an original will and you've got it hidden away somewhere, please let somebody know where that is. Next, after the objection, is someone filing for years support. If you are not a surviving spouse or not a minor child or acting on behalf of a minor child, and you have filed a petition to probate a will or a petition for letters of administration, and then all of a sudden the spouse or minor child comes in and files a petition for years support, well, that's going to basically put your petition on hold. And so, probating the will, because again, years support comes in front of everybody else, and that includes a will. So if you're probating someone's estate and someone files a petition for years support, you're going to have to stop and talk to some people. That's going to add considerably more time. If you have a personal representative who can't serve, usually because they've passed away, or who won't serve because they just don't want to, or they're mad at somebody, that's going to cause some additional time. I have a case right now where we have one executor named in the will, and she just doesn't want to do it. She's not responding to anybody. There was one phone call. She said, I just don't want to sign anything. Well, A, we got to move forward. And B, she probably would make a great executor in that case. So there we are having to kind of change direction and file a different petition. So that was a few months at least while we were trying to get in touch with her and get her to sign the documents and to serve. If you have a personal representative who lives out of state, it is very possible and relatively the same to probate a petition or to be the administrator, to probate an estate or to be the administrator of a state if you live outside the state of Georgia. Most of it is exactly the same. Most of it is not a problem. The big problem and the big delay that we see is that part of the probate process, when you're getting letters of administration or letters testamentary, is that the executor or the administrator has to take an oath with the court. Pre-COVID, you had to take that oath at the probate court, or you had to take it at a court local to where you live. So if you live in, some county in North Carolina, you would have to go to your county's court to take the oath. I don't know why Georgia requires it be in front of a judge, but they do. Pre-COVID, that would add probably another month or two as forms have to be mailed to the other probate court. Someone has to be contacted to go down to the court. They have to schedule it, take the oath. All the documents have to be signed by a whole bunch of people at the other court and then sent back. And in between the normal bureaucracy of getting mail out of a court and, mailing time back and forth, It added a lot of time to the process. The good news is, with COVID, a lot of courts have been taking these remotely. And so it's a much shorter period. So it's really actually easier right now to have an out-of-state administrator or executor than it was pre-COVID. And that is one of the things that I hope the courts continue to do, because it has made our lives much easier. The last one is if a personal representative can't get a bond. By default in Georgia law, an executor or an administrator has to get a bond for the full value of the estate. A bond is basically an insurance policy to make sure that the administrator or the executor doesn't, take the money and run. And under Georgia law, that's required. A will can waive that requirement, and most wills do. I've only got one or two that hasn't ever waived the bond. And in the case where there's no will, if all of the heirs agree to waive the bond, then you can waive the bond. But if even one of the heirs doesn't agree, then the administrator will have to get a bond and also have to do some additional paperwork. But getting a bond is kind of the main thing. Normally, you get a bond from your insurance company. So I tell people, call your homeowner's insurance, call your car insurance, see if they'll issue you a bond. If not, you can usually find somebody who will do it. But if for some reason their personal representative is completely unable to get a bond, that person can't be the personal representative, and we have to start over. I had one of those happen a long time ago, and we did have to go and find somebody else and essentially start all over again. So those are the complications. We don't run into these a lot. I'd probably say maybe about 30% of my estates have one of these or another, and so it's usually not too bad, but it is something that we have to deal with. If one of these comes up, you can't just ignore it. You kind of have to deal with them. All right, and that's it. That's a general overview, very high level, like I said, of probating an estate. So if you look down at the bottom of your Zoom window, you should have a little, like a little button that says chat, and it's got a talk, kind of like a little bubble like you'd see in comic books. So if you would post something either in the chat or in the Q&A, I'll take this time to answer questions if anybody has any questions. And I'll stop sharing while I'm waiting. Okay. All right. Someone asked, what does probate cost? It depends. That's the answer you're going to get from every lawyer. It depends. Usually the filing fees for those two main petitions are between $200 and $300. It varies a little bit from court to court. It varies greatly depending on how many heirs there are, whether or not they have to be served, which means, basically how cooperative they are. And it also depends on what additional documents you have to file. But in general, the probate, the filing fees, what I tell my clients, usually between $300 and $500 just for court costs and filing fees. Attorney's fees is going to vary from attorney to attorney. Some people charge a flat fee. Some people charge by the hour. It just kind of depends on who you're talking to. Let's see. Second question, does having assets in a trust avoid probate? Most of the time, yes, but only for the assets that are in the trust. So what we see sometimes is people will set up a trust and then they won't put assets into the trust, right? Somebody will go to an attorney, pay money, have a trust done to hold their house, and then never record a deed that puts the property into the trust, or they never change the ownership of a financial account. And there are still some situations in which a creditor can come into a trust and take some assets out in order to pay estate debts, but that's not all creditors. So in general, having an asset in a trust helps avoid you from having to probate it, to deal with it. Let's see. Another question. What if I own property in another state? That depends very much on the state that it's in. And so there are some states like West Virginia, Georgia's another one, where if the only thing that is in that particular state is real estate, you can simply record the will, and the will acts like a deed and conveys the property to whoever is named in the will. In other states, you would have to do what's called ancillary probate. And ancillary probate means you probate twice. You're going to do it here in Georgia, which is the state of residence, or you're going to have to do it and you'll also have to do it in the state where the additional assets are owned. This is one of the reasons why you'll hear a lot of estate planning attorneys say, get everything into one trust or get everything into an LLC. I'll sometimes tell my clients, if you have property in another state and you don't want to do the whole, trust deal, just create an LLC and make the LLC the owner of the property. And that will usually help you deal with that, because then what passes through the estate is the ownership of the company or the LLC itself and not the real estate. And you don't, if the company's here in Georgia and therefore the ownership interest in the company are here in Georgia, then you don't have to probate in another state. What changes hands is who owns the company. Let's see. Property located out of state and abroad. Yeah, we just answered that. Should I have co-executors? Ooh, that's a matter of opinion. And like I always tell people, if you have 10 lawyers in the room, you get 11 opinions. I'm not a fan of co-executors. It makes, it does add some complications, because now for all the things that do have to be signed, you have two people who have to sign them. And that's on the assumption that they get along and agree with each other. So, just having people who truly love each other and really want to do everything together, you're still going to add some additional days or possibly weeks just to get things signed, like checks to pay bills, or the probate filings with the court. And if those two people do not like each other and do not get along, well, everything just got a lot more complicated, which is going to add a lot of time and potentially a lot of expense. So I don't normally recommend co-executors, but if my clients tell me that they really, really want it, then I'll do it. But I'm not a fan. How's that? You could probably tell that. How long does probate usually take from start to finish? That's a great question. So I tell my clients 6 to 12 months for a standard, ordinary, everyday probate, anywhere from the day we file to the day somebody gets discharged, 6 to 12 months. Like I mentioned before, with those complications, there are a lot of things that can make it take longer. I have dealt with estates that are decades old. The estate that I've got right now that I started and we are still going is about it's going on 4 years old, just because it's a very, very complex will, and the situation is very complex. There were 2 pieces of real estate that had to be sold and all sorts of stuff. So how quickly someone can get appointed as the executor or the administrator of the estate varies a lot depending on the circumstances of the case. If there's a will and all the heirs cooperate, which is big, big if, and if the county is on the ball, because every county does things differently and takes different amounts of time to do it. I have had situations where when all the stars line up right, we had an executor appointed in a few weeks. That is very much an outlier. Most of the time pre-COVID, it was still 2 to 3 months before we could get an executor or an administrator appointed. Now with COVID, there are some counties like DeKalb that are still doing great. They're moving quickly. Things are going really, really well. It's going very smoothly. There are other counties that I will not name because I have cases out there where we're telling our clients, because the clerks are telling us, on top of the normal time, just add 3 months. It's just taking long. I've had some counties tell me they're still opening mail from 2 months ago. So there are some things we can do to speed the process along, but you generally can't call the court and tell them to, get on the ball. That's not great. Judges don't like that. Let's see. Did not answer about property owned in another country. Can it be listed in a will or a trust? I do not know. That is not something that I have any experience with. That's something I would have to research. So if you want to, if you want to hire me to research it, I can do it. Probably a better thing to do would be to talk to Kevin. I think he knows more about that. So I apologize. That's a question that I can't answer and shouldn't really try. Okay. Someone says, I have 2 kids, but they don't get along. Should I get a third party and you don't have any other family? So it's up to you. Like I tell my clients, that's completely your decision. If you want to get a third party, there are plenty of people available who can do it. If you don't have family, it could be a trusted friend. I've done several of those. If you don't want to burden a friend or a family member with that kind of responsibility, you could get a CPA. You could get a financial planner. You could get an attorney. I just want you to know that I am not allowed to suggest myself as your executor or trustee, just because Georgia law doesn't let me do that. So please make it clear I am not suggesting you hire me to be your executor. If you want to, you can, but now I'm going to get in trouble. So yes, you can get pretty much any competent adult to be the executor. You can name them in your will. It doesn't have to be a family member. And if you think that one or your other children serving as the executor would cause some friction, or if you think there's just going to be friction anyway and you don't want to burden one person with that, yeah, you can hire somebody. Executors get paid, by the way. So whether it's a family member or an outside person, they do get a small percentage. In Georgia, it's roughly 5%. I heard in some state it's 20%. So don't move there. But yeah, so they do get paid to do the job. Everybody who's an executor gets paid to do the job, but just realize that going in. Someone asked, when is the time are available to sell real estate? Okay, so the executor, the administrator can sell real estate after they are appointed, after they have their letters, and assuming that the letters properly grant the authority to sell real estate. That is something in Georgia that does not automatically happen. Just because someone's appointed executor or administrator, they don't automatically have the authority to sell real estate. When there's a will can give the authority to sell real estate, and all of my wills do. I normally recommend that. I don't want to say all good wills should, because that's rude, but yeah, most of the time a will grant authority to sell real estate. And just like with waiving the bond, if all the heirs agree to grant the authority to sell real estate, then they can. If all the heirs do not grant the authority, if even one of them says, no, I don't want to do it, well, then to sell real estate, the administrator has to file a separate petition called a petition for leave to sell. And now you've got an additional few months. So that's not great. I'm dealing with a will right now. It's basically, it's either a downloaded or somebody copied from someone else, and the will does not grant the authority to sell. And so we're filing to get the will probated, and then we're going to file a petition for leave to sell. And now we're looking at 6 months from the time somebody called me till the time they can, list and sell the property. Let's go back over to here. Small items such as furniture and left out of the trust. Does the pour over will take care of these items? Yes. If you have a pour over will, then yeah, it takes care of everything that's in your estate. And I'll define it. A pour over will is a will that basically says everything goes to my trust. Right? You've got the appointment of the executor, you've got all the other things that are part of the will, but instead of leaving something to, I leave this jewelry to this person, I leave this car to that person, I leave my house to so-and-so. A pour over will has one beneficiary, and it's an existing trust. So yes, if there are items that are not in your living trust when you pass away, then those items that are just owned by you will be handled by the pour over will. Let's see. Please define who are the heirs. The legal heirs are defined by Georgia law. And it's basically if there is a spouse and or children, your spouse and or children or both are your legal heirs. So if you are married but have no children and no descendants, your spouse is your legal heir, and that's it. If you have children or descendants through those children and are not married, then your children or the descendants are the legal heirs, right? When I say descendants, I mean things like grandchildren from a predeceased child. Then that child is not an heir. Their children, the living people, are your heirs. If you are married and have children or descendants, then it gets broken up according to a formula among your spouse and children or descendants. No spouse, no children, then it goes up to surviving parents, if there are any. If there's no surviving parents, it goes out to siblings and their descendants, and so on and so on and so on and so on. It just kind of keeps going out in these bizarre wings. Georgia does not have a cutoff. Some states, I've heard, don't quote me, some states do have some sort of cutoff. When you get to 15th cousin, they just stop. Georgia doesn't. But we're usually able to find somebody by the time we get out to second or third cousins. So that's who are heirs. It is only blood relatives or people who are in your family by adoption. Stepchildren are not heirs. Spouses, your children's spouses, in-laws, none of them are legal heirs under Georgia law. Somebody says, I just moved from New Jersey. Should I get a new will? If you come from out of state, there is a very good chance that your will is no longer valid. Like I said, each state has different requirements for a will, whether that is different signing requirements, right? Georgia requires that there be 2 witnesses to a will. A will needs to be in writing, signed by the person making the will, and signed by 2 witnesses. And so as long as it does that, it's a will. But there are states that have fewer witnesses requirements, right? If there's a state that just has 1 witness, and that's a perfectly valid will in what other state you live, and then you move here, it's no longer a valid will. It could be no longer a valid will because it's only got 1 witness. There are states that require 3 witnesses. So if you have a will done in Georgia with only 2 witnesses and you move to that state, that will may not be valid. In general, I recommend if you move to a different state or you move here from a different state, I'd go ahead and get another will. There are also things like waiving bond and granting the authority to sell real estate that may be assumed in other states, or that you may not have to put into a will, but you do need to put in Georgia. And so those sorts of things are generally good reasons to go ahead and at least talk to a probate attorney or an estate planning attorney about getting a new will. That's a good question. Let's see. Estate tax. I am not a CPA, and I am not qualified to tell you what taxes you should or should not pay. In general, my understanding is that there are 3 types of basically kind of types of taxes that have to be dealt with when someone passes away. The first, and the one you need to deal with most quickly, is the estate tax. That is a tax by the government that basically says, hey, please add up your total assets. Let us know how much it is. If it's over a certain amount, you're going to have to pay taxes on it. I believe the current exemption is in the range of $11.5 million per person. So if you have under $11.5 million per person, and then I think you're fine. Again, call a CPA, call Henry Spill here at Magellan, but don't call him until after October 15th, please. Then there is an individual income tax return. In general, you need to check and see whether that person needs to file an income tax return for the last year of their life. And again, that's going to be dependent on the situation. And then there is also sometimes an income tax return for the estate itself. In general, if the estate makes income over a certain amount, you'll need to also file a tax return for that estate. And again, so you have now reached the end of my knowledge about estate taxes and taxes regarding estates. So yeah, that's great. Again, please call an accountant to clarify what I just said. Someone asked, should I put my kids on my checking account if I'm a single widow to avoid probate? That's up to you. So let me tell you what happens if you put someone on your account. If you put someone else on a checking account, or basically what you're doing is making them a joint owner of the account. And you can do that with one person, you can do that with more people. When someone is on your checking account as a joint owner, or when any people own something jointly, whether it's a financial account, like a savings account, checking account, or whether it's something like real estate, when one of the owners dies, if it's a joint account or if it's jointly owned property, one of the owners dies, the remaining owners automatically are the owners of all the assets that are in the property, that are in the account. In the case where, let's say, for example, you have one child and you want to put them on, then yeah, and if you want that child to receive all the assets, then that's fine, because it's going to go where you want it to go. And by the way, that avoids having to probate that account, because it happens automatically, just like life insurance happens automatically. If you're in a situation, for example, I have 4 children, I have 4 sons. Pardon me. I'm going to need some water. Okay, I have 4 sons. And let's say, for example, like in a lot of situations, 3 of my sons move out, move away, they're doing their thing, and one of my kids sticks around to help us out as we get older. In a lot of situations like that, people will put the caretaker child, or the one who is helping them out the most, they'll put the caretaker child on the account and leave everybody else out. And then they'll go and make a will that says, I want everything to go to, all my kids equally. Well, what happens is when mom dies, the child, the caretaker child, who is a joint owner on the account, all of a sudden is the owner of all the assets in the checking account, regardless of whether the will says mom wanted it to go to all these people. And then you have a situation because then you have one person who owns all these assets and the other three people who are not going to receive it because it's not part of the estate, and therefore the will won't touch it. So what I tell my clients in that situation is, if you want to avoid a family fight, and if you want to avoid bad blood for the next 20, 30 years, I think you should consider going ahead and dividing that money up, but they're not legally required to do so. In most situations like that, where they truly are a joint owner of the account. So the answer is, would I recommend? I really can't say. That's hewing very close to legal advice, and it's going to depend on case by case. There are other ways to deal with that. Other ways to avoid probate with an account, and there are other ways to have someone be on your account so that they can help you write checks or deal with finances, usually through a power of attorney. So putting someone else on an account can cause problems and is not the only way to resolve those two potential issues. Do IRAs go through probate? I'm not the investment guy, so I'm not the proper person to ask that question. You may want to call and talk with Kevin or with Lynn. Generally, my understanding is that IRAs and most other financial accounts will have either a pay on death beneficiary or a transfer on death beneficiary, which means if those accounts are that type of account, then when the owner dies, it immediately goes to the person who is named as the beneficiary. And in that case, I don't believe it passes through probate. It just like life insurance, it goes directly to the person and the will doesn't touch it. But again, I would talk to Kevin or Lynn or somebody else about your account to find out what's going to happen to your account specifically when you pass away. Let's see. Can a joint tenant owner's creditors get at the assets, bank accounts such as a lawsuit or bankruptcy? It depends. It depends a lot on the circumstances. While someone is alive, let's say, for example, my wife and I own our house as joint tenants with right of survivorship. We're co-owners of the property. While I'm alive, if I do something dumb, like run off to Las Vegas and run up a huge gambling debt, and then my creditors come after me, then yes, because I am at that point an owner of an interest in property, they can try to collect from my half of the house. If I die and the property automatically becomes my wife's, she becomes the full owner, and then my creditors come and try to collect from my house, in most cases they cannot because it's not my house. Once I die, that asset is no longer mine. Now, there are a lot of things that people can do wrong. So, for example, if you already have a known creditor and you decide you want to try to transfer away property to avoid having that property be available for your creditors to collect, don't do that. Talk to an attorney first. That may be very illegal. As for someone's after someone dies and the joint tenancy property, there are certain situations in which certain creditors can try to collect from the joint tenant property even after someone has died. Again, that's a very, very case-specific situation, and we'd have to have a different conversation about that. Okay, yeah, again, I'm sorry, I'm a lawyer. I can't answer questions I'm not qualified to answer. So sorry. Let's see. I think that's all the questions. Let me look back through and see if there's anything that I've missed, or if somebody else wants to ask a question, you certainly may. Let's see. Okay. Is there anything else? Nope. Okay. That's it. Let me put my information back up there real quick. Put it back up on the screen so that you can get in touch with me if you have any questions, or if you want to you can just call the Magellan main number and that information will be available. You can get in touch with me, and there it is. So again, my name is Scott Fields, working with Magellan Legal. The number here, 404-257-8811. You can reach me at scott@magellanlegal.com, and our website is www.magellanlegal.com. Let's see. Late question. Do you have to probate a pour over will? Yes. If there are assets in the estate, even if it's a pour over will, you have to probate the will. You have to probate a will in Georgia. Wills don't just automatically happen. They always have to go in front of a judge. They always have to go to a court if there are assets to be dealt with. If you've put everything into a trust and if there literally is nothing, if there are no assets at all, then it's a good question about whether or not you need to probate the will. The problem that I run into is that a lot of people think there are no assets in the estate when there actually are. So I'd probably say way more than half of the people who have come to me and said, oh, there's no assets in the estate, I don't need to probate the estate. Once we've had a short conversation, we find out that, well, there actually are assets. And yes, you do need to probate the estate. A pour over will just refers to where the assets go. Instead of going to a number of beneficiaries, it just goes to the one beneficiary, which is the existing trust. Okay. All right. Well, that's it. Thank you again for your time, and I look forward to talking with you in the future about some different things relating to probate. Y'all have a good afternoon. Bye.